But I am so pleased that they asked me to speak today. This is a topic that we feel passionate about in my practice. People call us, and we try to, we see ourselves as being a gateway, more than anything, to help people find the help that they need. In addition, I come across exploitation and abuse, and people don't even know that it exists. And so we will have clients come to us, and when they are asking for things, red flags come up. And so then we will try to investigate with the family as much as we are able, between attorney-client privilege can get in the way of some of our looking into situations, but at least we can point families in the right direction, or in the alternative, try to get other family members involved in the situation, because very frequently the family that has brought the elder to us are the exploiters and not necessarily the family members that are not doing that. So, because I deal a lot with money, and if you haven't noticed, money when it comes to elders is something that causes a great deal of dissension among family members, can cause a great deal of issues in the greater community. With that video that you guys were watching, money seems to be the thing that I always say, if we could just take it out of the equation, things could be different and we might be able to work this out, but we all know that that's not going to happen. So we need to learn to deal with it and learn to work with it. So the way that I see as working best is to work within the system, to make sure that the elder has the documents in place so that either A, they can deal with things themselves in an appropriate manner, and I am always an advocate of someone who is well able to deal with things doing that, or B, bring in the appropriate person that can help us straighten out the situation if the elder is not able to do that on his or her own. So documents is the very first thing I ask my clients when they come to my office. And it's, I hope, the thing that people that are working in the facilities that are dealing with elders out in the community are aware of as well. That child, that sibling, that person that presents with the elder at a doctor's office, at a bank, he or she better have the right paperwork. And people that are surrounding that elder, that are dealing with them from the other side, should be asking for that paperwork. Because just to, and I find this is more an issue in the financial community than it is in the healthcare community. Healthcare workers are very good about asking for that healthcare power of attorney before anything else goes forward. It's part of the intake paperwork. It is not so much part of the intake paperwork when it comes to investment companies, banks, those kinds of institutions, and especially in the small towns. When a small town banker has a relationship with the family, they may just start dealing with the son or the daughter and skip right over the elder without that paperwork in place that they need to deal with. So we want to make sure that even though we've known the people for centuries, for generations and generations, this particular situation may be something that needs looking into. So that's what I do over and over again. The best tool to help fight the things that the entry level tool that people use to fight things is a financial power of attorney. And a financial power of attorney, people walk into my office and ask about their documents. They're like, oh no, I'm not going to do a financial power of attorney because I don't want to give away my power to somebody else. I'm not ready for that. And I always explain over and over again that a financial power of attorney is something that you draft, you work with an attorney to draft for you and sign when you are well, so that someone can take care of you when you are no longer able to take care of them. So if you are unable or unwilling to take care of your own financial affairs, a financial power of attorney can step in and do that for you. But it needs to be done when you still have the capacity to do so. So I'm not going to spend a lot of time talking about capacity today. I know that is a huge area. We're going to probably have a whole day on that alone as to what capacity is and what it is not. Suffice to say, though, that the capacity for a financial power of attorney is, in my world, pretty low. So if someone is able to indicate that someone can do something for them, and it is a reasonable choice. It's not the nice lady from church that found out that you have money. It's not the person that comes in and mows your yard. It is your son, your daughter, your spouse. So that's another misconception. Unless all of your assets are jointly held, you may or may not be able to do the things that you need to do for your spouse without a financial power of attorney. As a matter of fact, I would say more often than not, you're not going to be able to do things for your spouse unless you have that properly executed financial power of attorney on their stead. You certainly aren't going to be able to apply for benefits for them. You're not going to be able to get them on Medicaid. You're not going to be able to call Medicare and talk to anybody about them. You're certainly not going to be able to deal with bank accounts and those kinds of things. So you even need a financial power of attorney for your spouse. And one of the things that happens in my world is that someone has properly done their documents, but then their spouse becomes impaired and they don't appoint someone else. So if effectively we don't have a power of attorney in place any longer. So we will frequently, when someone comes to us and something, the bad event in our elder law world has happened, a diagnosis, a death, something like that, that power of attorney is now no longer in the picture. We have to step back and try to figure out what we're going to do about replacing that power of attorney and who that power of attorney might be. So the best person to contact for power of attorney is basically an attorney. I mean, certainly they are on the internet, and if you're not going to go to a lawyer, it is better than scratching it out on the back of a piece of envelope or a piece of notebook paper, because you're not going to go through the formalities that are going to actually create a valid legal document by doing so. The other thing that you need to watch out for as being providers is people that alter their own documents. So they already have a financial power of attorney, and daughter number one has ticked them off, and now we want daughter number two to be power of attorney. So we just line through daughter number one and write in daughter number two. It isn't going to fly. I mean, if a bank takes that, if someone does that, they are doing that in error, and that document needs to be redone. So I have clients bring that to me all the time. They will just change things on their own, still signed at the bottom, yay, but you have changed your people. And they've even done it back. So daughter number one irritates them, they go to daughter number two, and then they go back to daughter number one when she's back in good graces. So you need to keep these things up to date, have a relationship with an attorney, and discourage the elder from changing their documents by themselves. And most people leave my office, I always say, you know, if you need any changes, if you want any changes, you got to come back to me and let me do this for you. Because also that flopping back and forth of powers of attorney can be a red flag. It can show us that either their family is not dealing with their situation very well, or that elder is having capacity issues on their own, that they are changing their mind, that they are unsure, and that by changing their power of attorney back and forth, they're trying to exert some control over their world, and that can be a red flag that can cause us issues. What do powers of attorney do? Financial powers of attorney can do almost anything from the most limited. So when someone comes to our office and asks us to apply for Medicaid for them, we have them sign a very limited power of attorney appointing our office as the limited power of attorney for the purposes of applying for Medicaid. So just that one little job. So that can happen. All the way to the Iowa is a Uniform Power of Attorney Act state, where it says that every single thing that someone does for someone in a financial capacity needs to be delineated. Annuities, stocks, bonds, picking up the mail. Within the next few years, the post office is going to start asking you to present a power of attorney to pick up someone's mail. And it seems reasonable to me, because that certainly could be a place of exploitation or abuse if someone is grabbing that elder's mail and should not be doing that, and then the guise of being helpful, the neighbor is bringing stuff to them, and gosh, he sees a check. That kind of thing can be problematic. And so many in the rural areas are not getting the mail delivered to their homes anymore. They're going and picking it up in town, or it's down at the bottom of the street, and they don't walk down and get it, and some helpful neighbor is bringing it up to them. So a power of attorney is going to be asked for to get mail in the near future. So a power of attorney basically can do a whole lot of things for the person that they're asked to do things for. And what's most important is once that document is signed, that document get to the bank, that it get to Ed Jones, that it get to anybody that is going to have any financial doings with that elder. Now, powers of attorney can come and go. So once they are being used by the elder, it doesn't mean they're going to be forever. Now, we know that at some point in someone's dementia journey, that power of attorney may be invoked, usually by a doctor's note, and then become invoked forever. Someone's going to be taking care of their finances for the foreseeable future. So far, nobody has recovered usually from Alzheimer's and not been able to take over their finances. However, some of our seniors travel, so they'll travel extensively and they will choose not to take care of their finances while they're traveling. Or they could be like my mom, who's 81 years old and has absolutely no capacity issues, but my dad paid her bills their whole 55-year marriage, and by gosh, when he died, she wasn't going to start, so she has a lawyer daughter who can do that. So I do that for her because she chooses to have me do it. And theoretically, she could take it back at any time if she didn't like the way I was doing things. So far, she has not. But I would say, though, that if she calls me up and says that she wants to send $10,000 to a bank, to a post office box because she's getting in the Nigerian lottery, I will probably intervene at that point and not let that happen. All right? So they're required to work in their elder's best interest to maintain accurate records. So I tell everybody, if you're going to be somebody's financial power of attorney, get yourself an accordion file, the one kind with months on it. And if you're going to go out and be shopping for mom with your debit card, take hers too. Put a stick in between your purchases and her purchases. Keep your lives separately. Don't use mom's checkbook to pay your bills. Don't use your checkbook to pay mom's bills, unless she's absolutely indigent, and that's another discussion topic entirely. But even if you are out and about and running errands, keep things separately. Be able to show DHS, anybody who asks, that you have receipts for what you've done, that money that you have written, perhaps if you are paying, you're living together, which would be a lovely thing in some families. You're paying utilities, show that you are paying utilities right in that little line, the gas bill, whatever, that you're not just taking money from mom for your own use. In my practice as well, we do something called caregiver agreements, where we actually come to terms as to how much money mom is going to pay living in your home, or if you're living at home with mom, how much you're going to pay, however that's going to work, because we know that if it ever comes time to apply for Medicaid and money has passed between parent and child, we need to be able to show DHHS that DHS, and Nebraska DHH, but we need to be able to show them that it was not gifting, that it was not intentional deprivation. So we need to be able to track that money. So records are huge. And when somebody is a power of attorney in my office, I teach them how to be a good power of attorney, because there's the right way and the wrong way. And commingling money is absolutely the wrong way. They can pay taxes, they can pay bills, they can collect government benefits. That's a huge part of what a power of attorney may do. File taxes and perform other duties related to finances. So people come to me and say, well, you know what, I'm going to be power of attorney for mom. What am I exposing myself to by doing this? And actually, it is the prudent person standard. So you should do whatever a prudent person would do. That's not a heightened standard unless you're an attorney or a financial advisor. So you just do your best. And if mom says, I want to change my investments, and you do that and they tank, that's not your fault. You have done your best. If you are doing things for mom and it doesn't turn out as she would choose, you don't have liability for that. What you do have liability for is taking mom's money and doing something for yourself, doing things that are not what she would ask you to do, or doing something that would be completely out of the realm of possibility, sending money to that Nigerian bank account. But liability is usually not an issue as long as you are keeping records, not commingling funds, and doing your best under the circumstances that you've been dealt. All right? Now we'll go to healthcare. Healthcare power of attorney is another way that we can keep our elders from being exploited. You can get involved in your loved one's healthcare, and you can do it in one of two ways, basically. Healthcare power of attorney is the strongest way, and that's where they appoint you to actually make healthcare decisions if they are unable or unwilling. Again, there's a continuum from I appoint my daughter Mary to make healthcare decisions for me, boom, done. Don't give her any directions as to what I want her to do. She is simply empowered to sign on the dotted line, right? All the way to the more extensive medical directives where I tell Mary how I want her to do things should I ever not be able to speak for myself. I tell her how I feel about those end-of-life issues. I tell her how I feel about intervention as things progress. I talk about these things while I am still able. And I always say, you know what, this is the kind of thing that you have a glass of wine and sit down and get real mellow, because these are hard things to talk about. But they're absolutely necessary if you're gonna make decisions for somebody else, to know how they feel about things, what they would do in a given situation, so that you can respond in the way that they would choose to have you respond. And we do that in my office with something called 5 wishes very often, and that talks about 5 different circumstances that can happen as we age. And it allows you to start that dialogue back and forth. There are several of those floating around. Most of the big UNMC and CHI have kind of analogous documents where you can write things down. But mostly communication is going to be the key to this whole thing. Make sure that you are talking to that person that you care about what they want to do and how they want things handled. Healthcare powers of attorney, if possible, should also be going to doctor's appointments. They should be listening as when the doctor says things, because if the doctor's changing medications, talking about diagnoses, I mean, certainly if they say something like the big C, that person's gonna just shut down and not listen to anything else that comes along. And they're not gonna understand that maybe what he just said is completely treatable, we're gonna get over this and go on with our life. Going to things, being able to be that listening ear, I mean, that's good for if you're 18 or 88, having somebody in the room. I usually go to the hospital, I usually go to doctor's appointment with my husband because he doesn't ask any questions. He just sits there and he comes home and I says, so what did he say about that rash on your arm? He goes, well, he gave me some stuff. I said, well, what did he say it was? I don't know, but he gave me some stuff. It's like, okay, that was not the point here. You know, I want to know whether it's eczema or psoriasis
Contagious.
or skin cancer. Yeah, exactly. Whether it's communicable.
Oh.
This is important, right? But he doesn't ask those questions. He just does what the doctor says, and he's very, very passive. I find my mom to be equally passive. It was what her generation was kind of taught to do. Doctors were on a pedestal, and you didn't question them about what they were saying, and they continue to do that as they age. And that can become very problematic because, as we know, there's a wide range of choices that can be made in a lot of different situations. And collecting information and really sifting through that can be important. So we always say, you know, if you can take somebody with you. That kind of circles back around to the difference between financial powers of attorney and healthcare powers of attorney. Because I have clients, one client in particular, who lives at Nye Point in Fremont, Nebraska, and has his daughter lives in Virginia and his son lives in Paris. And they deal with his finances just fine. They do it online, they do it over the phone. They have hired someone locally to serve as a surrogate healthcare power of attorney because he needs somebody to go to the doctor with him and to deal with his healthcare because they are not here. But a financial power of attorney can live far away if that's all you've got. And we are a very mobile society, so being far away is something that sometimes happens. You know, mom and dad live in a small town, and the kids move to Des Moines or Davenport or Omaha, and they're not there anymore. But the healthcare power of attorney, I have a rule of 45. You need to be 45 minutes away or 45 miles away because you need to be able to get to the emergency room. And if that means that it's a trusted neighbor or somebody from church or somebody like that that can go there and then be on the phone with the kid that lives in Virginia making decisions, just so that elder doesn't end up in the ambulance at the emergency room alone. I mean, that is a huge consideration because that is not going to be a situation where good decisions are going to be made. Certainly kids can hop on planes, but it's going to take them, I mean, even from Denver, 4 or 5 hours to get there if they have to, or from Chicago. Driving, you know, that's always a problem, especially these days when all the roads are covered by water. But you know, people need to be able to be present with their loved one when healthcare decisions need to be made. And especially, and medications are so complex. I think I had a lady in my office the other day that was taking 24 different kinds of meds. Now we had a pill minder, you know, one of those ones that pops up and whirs around. But if something changes in her world, she can't keep track of all those meds. So she does have someone that goes with her, and it is a paid caregiver, and that is a reasonable solution as well. But she goes with her to her doctor's appointments because her kids live out of town. And then she reports back to the kids. The kids come in frequently to be with mom. So it works. It's not the best thing, but it can work. But that healthcare power of attorney needs to be much more accessible than the financial power of attorney. And that document, too, as soon as it's signed, needs to go to the doctor, go to the hospital, be where that person is going to be. Now, lawyers in both Iowa and Nebraska cannot execute DNRs and DNIs. So if that is the point where a client is at, where they want a do not intubate or do not resuscitate order, that is an order, probably preaching to the choir, that is, comes down from a doctor. That is, it's a written prescription kind of thing. And if they need that and they are home, that needs to be at home with them. It needs to be prominently displayed, and we talk about that with my clients as well. Make sure that that's something somebody can put their hands on very quickly. Healthcare power of attorney, not so much. That really should be at the doctor's office, at the hospital. It should be other places, because that's going to be where you receive your care. The EMT that comes to your house does not give a damn who is listed on the power of attorney. They are simply going to deal with the emergency in front of them and then transport, and that's what that's going to happen. But the financial healthcare powers of attorney are going to be referenced. They're going to be scanned. They're going to be in somebody's records, and hopefully somebody's going to consult them before any decisions are made or before anything is signed. All right. Next slide. So you have somebody in front of you who has decided that they are not going to do